Welcome to another episode of Chronic Detrimental. Dan Luss, Dan Wallach, and a special guest this week, Ben Fischer of the Sports Business Journal. Dan, one topic this week, we're going to talk about a lawsuit that has certainly been underreported in the media and one that is on the verge of trial. That is Oliver Luck versus the XFL. Yes, the original, actually, we'll say the second incarnation of the XFL. So as everyone knows, the XFL was created in the early 2000s. It was defunct for a little bit, and then Vince McMahon brought it back in 2018. It only hung around for about 2 years before it went out of business and then was bought out of bankruptcy by The Rock, and now it's going to come back. So we'll say now the current XFL is in its third iteration, but this lawsuit pertains very specifically to Oliver Luck, who was appointed as the commissioner, paid about $5 million a year, and he's going after Vince McMahon. He thought he was wrongfully terminated. So, Dan, before we kick it to Ben, high-level thoughts on this lawsuit.
A breach of contract case that has yielded over 500 docket entries in a 2-year period. I mean, it's almost unprecedented. You see these happen in class action lawsuits, very sophisticated, complex commercial class actions. This is kind of a narrow issue. Is Luck owed, monies under his contract? Was there justification for firing him? That's it. It's just simply an employment dispute, and it's yielded over 500 entries in such a tight period of time. It gives you some window into how these litigants are treating this case. They're going like scorched earth, at least McMahon's side is, and making Luck's legal team earn every cent of every amount of money coming to him. So I found that to be very interesting, that you can really tell what kind of relationship the parties and the lawyers have by looking at the docket. And this docket reveals a poisoned relationship if the number of docket entries and the type of motions being filed are any indication.
So I think, Dan, that sets the stage well. And again, we're going to be joined in a few minutes by Ben Fischer of the Sports Business Journal. This dispute really centers on, we'll say, three parties, Dan. And obviously Oliver Luck, who people will know, he was, a high executive at the NCAA, worked for the Houston Dynamo and the MLS. He's had different jobs throughout sports, but maybe people know him most famously as being Andrew Luck's father. Yes, that same Andrew Luck, number 1 overall pick once upon a time to the Indianapolis Colts. He was just a sports executive in his own right. So McMahon, trying to make a splash with the XFL, hires Oliver Luck, who at the time might have been one of the premier names in the field and still certainly is. But he launches this new venture. He announces Oliver Luck as the commissioner. And, as some of the core tenets of this league, he said, right, we're not going to sign players with a criminal past, and we're not going to, sign players that kneel for the national anthem. I guess that second issue doesn't come up in this case because Colin Kaepernick is not involved. But the other player that's involved here is certainly Vince McMahon, right? The main guy behind the WWE, who he was originally with WWF. He made wrestling kind of a international business. He used to be in the territorial system. I know way too much about wrestling, but at the time I was a stockholder of the WWE, so I was very intrigued as to what he was going to do with the XFL. So the other third player here, we said there was one. So there's Luck, who we've explained, and everybody knows Vince McMahon. The third one here is Antonio Callaway. Yes, that Antonio Callaway from people probably remember him from the Hard Knock season of Cleveland Browns. He was a 4th-round pick. He went to the University of Florida. A guy that probably had more talent than a normal 4th-round pick, but he did have one of these checkered histories. So we're going to certainly get into it, Ben. Dan, you want to kind of frame the Antonio Callaway isms in this case, why Antonio Callaway is central to this case?
The reason why Antonio Callaway is so important, Dan, is that the singular issue in this case really turns on Antonio Callaway and whether Luck's decision to sign him as a free agent within the league violated Luck's contract with Alpha and the guarantee with Vince McMahon by signing a player with a little bit of a checkered past. And what happened was Callaway was signed. McMahon tells him you got to terminate his contract because of his history. Luck conveys those directions to his head coach, Mark Trestman, and Trestman allows him to practice. And what happens? Callaway suffers a serious injury and collects the entirety of his contract. And there's no real opportunity to terminate Antonio Callaway without paying him the entire amount due on his contract. So the question in the case is, did Oliver Luck breach his employment agreement? Does this justify the decision to fire Luck with cause? Was there too much delay in the decision to fire Luck because that decision was not made until several months later? And then Luck will, of course, raise as a backup defense, well, if it did violate the terms of the contract, I could have cured it. And McMahon and Alpha did not give me a sufficient notice or an opportunity to cure this alleged violation. So this multi-million-dollar, $24 million contract dispute comes down to this singular issue, which focuses entirely on the 6-day saga surrounding Antonio Callaway.
So I think that's a good place to put a pin in it, Dan. We have Ben Fischer joining us. Ben Fischer is a writer for the NFL and for the Sports Business Journal. He's on social media at Ben Fischer SBJ. We'll get into briefly. He was on with us for one of our more popular episodes, really our first installment of the St. Louis Rams relocation saga. So Ben is usually at the crux of this. He's pretty keyed into these issues, and he was the one that said, "Hey, are you guys paying attention to this July 11th trial date?" And, then we got together, we roundtabled it. And now Ben, in addition to this podcast, has an article out now on the Sports Business Journal covering this particular story for more information. And Dan and I are certainly quoted in it, but Ben is someone to watch his feed for anything and everything on this particular case. Okay, before we kick it to Ben, podcast sponsored by Themis Bar Review, top bar prep company in the galaxy. Dan, as you mentioned, this case really pertains to a breach of contract issue. We can make it more complicated. People might think that the bankruptcy is involved here. It is to some extent, but The Rock is not a party to this case. I'm sorry to disappoint some people. But this is a pure breach of contract case. And if you're looking to learn about breach of contract suits, or really anything about breach of contract, certainly you can listen to this podcast. But if you're studying for the bar, Themis Bar Review, head to themisbar.com/con-detrimental. Okay, Dan, I think it's about time. Let us kick it over to Ben Fischer. Ben, welcome back to Conduct Detrimental. How are you?
I'm great. Thanks for having me.
The last time you were with us was with the St. Louis Rams litigation and that fun fraud relocation suit. So now we have you back on for a special story on this XFL, Vince McMahon, Oliver Luck saga. So, Ben, it's a story that you kind of brought to our attention. This trial date was coming up. For those that haven't seen it, Ben's got a story out now on Sports Business Journal. But, Ben, we'll give it to you. Why don't you paint the scene here on this interesting dispute and this upcoming trial we have?
Sure. So I'm going to assume that most of our listeners remember that Oliver Luck and the XFL in 2020 went out of business abruptly shortly after the pandemic started. And many of you probably also remember that Vince McMahon claimed he fired Oliver Luck for cause, even though it was in the midst of a wind down of the league. And they are still in court over that. Oliver Luck filed a wrongful termination suit a few weeks later, saying he's owed his full salary and benefits and bonuses for his remaining time on his contract, which adds up to about $24 million. They're still in court. I think a lot of us assumed they would settle for something between 24 million and zero, but that's not how Vince McMahon does business. And now they appear to be likely to head into a trial in July. A lot's happened on then. The judge kicked out some of Vince McMahon's arguments for cause, actually most of them, but did keep one matter in particular that seems unbelievably narrow set of facts to be talking about $24 million. But here we are, we've got a trial. It's set for July 11th, and I see little indication from background conversations that this is not going to go to trial. So it could be a blockbuster week in Connecticut federal court in July.
For a $20 million suit involving the XFL, the WWE, Vince McMahon, and Oliver Luck, you'd think this would be getting more attention, especially, Dan and I had a chance to go through the docket on this case, and there's literally hundreds of entries. And maybe the interesting part about this, the majority of those entries are sealed. So we're trying to give our best guesses on what's going on here. There certainly was a lot to kind of decipher maybe this last week or so with pretrial memos going out, and also this motion to compel motion for sealing. Ben, I guess let's kind of like rewind, right? Let's take us back a couple years ago when Vince McMahon announces the relaunch of the XFL. And I remember this pretty well as a former stockholder of the WWE. I remember thinking, like, why is Vince McMahon going back to the well of the XFL? It's not like that venture was so successful the first time around. And remember the landscape, right? This was pre the USFL being launched. It was pre like Spring League and all these other leagues coming up. And Vince McMahon wanted to be the one to kind of, I guess, go kind of create an alternative program for the XFL. So I remember this well, that he said one of the core tenets of the XFL is that we are not going to have players that maybe have a criminal background, a checkered past. I remember him saying that in an earnings call. And again, I was watching very closely as a WWE stockholder. I'm like, okay, that's interesting. So the question was, like, would they get guys like Johnny Manziel to play quarterback? The guy's got a checkered past. Could they get a guy like Tim Tebow? Sure, because he has no checkered past. But you mentioned, Ben, and maybe Dan, I'll give this to you, right? we can get into what was initially part of Vince McMahon's defenses here, but Oliver Luck is, accusing that he was fired without cause, and Vince McMahon is saying he was fired with cause. Dan, maybe I'll give it to you. What do you think, what's left of the defenses here? I mean, I don't want to bury the lead here, but I feel like you have a lot of thoughts on what's remaining from McMahon's defenses.
Well, I mean, this case started as a breach of contract suit where the cause termination that McMahon raised was based on a lot of myriad things, such as misuse of his cell phone, sharing, information with his brother-in-law who worked for the Wasserman Media Group, abandoning his post after the pandemic. I mean, McMahon raised a laundry list, bullet point worth of items that, in his mind, gave him reason to fire Luck after the XFL folded. And the one claim that remains after the federal district court judge pared everything down, rejected all of McMahon's defenses, the one claim that remains centers on a wide receiver named Antonio Callaway. So, Ben, can you sort of set the stage on who Antonio Callaway was and sort of the set of circumstances that led Luck to sign him and what happened to him and why that's so important in this case? In fact, it's the main issue in the case.
Right. The judge was fairly frank in kicking out the other Vince McMahon defenses, saying they were pretextual and didn't really carry a lot of water. But this Callaway thing seems to have legs. And the basic background there is that Antonio Callaway was a promising wide receiver, still a young man, really. He had a very strong year for the Cleveland Browns, I think in 2017 or 18. Then had some injuries, is never quite the same, was the sort of guy a secondary league like the XFL might really make hay with. He's a guy that, sort of circumstances made life in the NFL difficult, but he might have been a star for the XFL. However, he's got a classic sort of bad boy rap sheet. No one thing that sent him away to prison, just a laundry list of things. He served a suspension for performance enhancing drugs. He was charged with and cleared of sexual assault in college. Various drug matters. Anyway, he's definitely the sort of guy Vince McMahon was talking about when he said we were going to have a clean league. And in January of 2020, before the season started, Oliver Luck signed into a contract. And it was like 6 or 7 days before Antonio Callaway got hurt in a practice for the Tampa Bay Vipers, which then made it so he couldn't be cut. And the league owed him a full signing bonus and workman's comp. And Vince McMahon says Oliver Luck did that in express contravention of his wishes to not sign him. And that's cause. Is it inconsequential as Antonio Callaway's XFL career may have been? A jury may well consider that cause.
Ben, let's focus a little bit more on the timing because this is the crux of the case. So Oliver Luck, in his sort of duties as commissioner of the XFL, has Antonio Callaway signed to a contract on January 30th. Or thereabout. What does Vince McMahon do next? Vince McMahon gives him some kind of guidance or instruction to terminate the contract.
Right, and I should say that this is one of those situations. This conversation is really harmed by how extensively sealed some of these case files are. There's affidavits and records reduced into the record here, so we don't know exactly what the nature of the conversation was. But the agreed upon facts in the pretrial memo say that McMahon and Luck talked about players who were sort of borderline character issues in like mid-January before the contract with Callaway was executed. And they also had a conversation like 5 days after he was signed, but before he practiced. And, McMahon is going to argue that he instructed Oliver Luck to release him. And it didn't happen until after he got hurt when they couldn't.
Luck had a conversation with the head coach, Mark Trestman, who a lot of NFL followers are going to be familiar with. He coached the Chicago Bears and was a respected, quarterback coach in the NFL. Oliver Luck did convey the message to Mark Trestman that Callaway, should be terminated. And I guess Trestman talked him into allowing him to practice. We'll talk to the agent. And following that practice, Callaway will be cut. But, as these things tend to happen, Callaway suffered a serious injury during the one practice. And as a result, earned the full guarantee because he couldn't, be cut because of an injury. And there lies sort of the problem that one extra day sort of created this, major legal issue. If he had been cut immediately, then there wouldn't have been an issue. But the question I have, and I think we've debated this a little bit before, what, if anything, did the XFL do or did Vince McMahon do to put Oliver Luck's job status in any jeopardy? I mean, this event happened on January 30th. The league continued to do business for another couple of months before shutting down due to the pandemic. Yet during all this time, Oliver Luck remained the face of the XFL. He kept getting paid every week or every other week by McMahon and the XFL. He was never fired. It was business as usual. So how important is that fact in determining whether this transgression rises to the level of being a for-cause termination? I mean, Ben, you have a contract with Sports Business Journal, and what if new ownership came in and said, look at this thing you did 5 years ago. We're going to terminate your contract because of what you did a long time ago, because the contract says we could terminate you for cause, quote unquote, at any time. How consequential is this delay?
Well, I don't think we know the answer to that question yet, because there's some pretrial motions that are asking the judge to craft the trial down a certain path. McMahon has asked the judge to not allow any discussion of what happened between those two. Their argument is going to be that cause is cause, and there's nothing in the contract that obligates him to say anything was wrong because this is uncurable. That's an issue we can get to in a second. But I think from a reasonable layman's viewpoint, jumping into this case, that's extremely compelling argument in favor of Luck, that he supposedly signed Antonio Callaway in January to the extraordinary detriment of the league, cause enough to unwind a $30-some million contract, but was never actually admonished for that until April 9th, the day before they laid off every employee and 3 days before they declared bankruptcy. So, I mean, a layman's perspective of this is that that is a pretext after the fact. However, McMahon's lawyers are going to say that we did talk about this. We thought it would be bad look to fire Oliver Luck. We were very upset about this, but we weren't going to fire the commissioner on the cusp of starting the season in February. And it was in the back of our mind. It was something we were going to evaluate after the season. And then once the pandemic blew up the league, there was no point in playing that PR game anymore. So therefore the cause comes in. So that's what's going to be argued in trial. There's not currently public evidence to that effect in the record that's not sealed. So I guess I can't say definitively.
So why we're spending so much time on this, the remaining issue that's left for trial, it's really one issue, right? It's Antonio Callaway. Was the hiring and the failure to fire Callaway, is that could that rise to the level of, justifiable cause for firing someone? And then, right, the second issue, right, if you can show that, was this the type of event that was actually curable, right? That's the other part of this issue here. So under Luck's employment contract, he had to be given written notice of some type of fireable type event, and he had to be given 30 days to potentially cure it. Now, the question that the judge is asking in this case is the hiring and failure to fire Antonio Callaway, is that something that's even curable? Right. So, Ben, we hit it fairly quickly, but I think this timeline is important. January 13th is when Mr. Luck receives an audit of Antonio Callaway's social media, which speaks to his suspension from University of Florida for sexual assault allegations. Right. And then there's some media coverage that Luck knows about, about drug issues. To some extent, Luck is on notice. It's not just the three of us, what's in the public sphere. It is kind of important about what Luck knows that particular period of time. So about 6 months prior, in July of 2019, Mr. Luck states that McMahon agreed to the following four criterion of guys that would equate to a true checkered past, according to McMahon. So that's someone that has a felony charge or conviction, which as far as we are aware, Antonio Callaway did not. It never rose to a felony charge or conviction. Any credible allegations of domestic violence. So there's sexual assault allegations. I'm not sure if that necessarily equates to domestic violence. Any repeat misdemeanor. I don't think necessarily, at least what we know, Antonio Callaway qualifies for that. And then 4, any conviction of distributing illegal drugs. And I think Callaway took a plea, but I don't think it was to distributing illegal drugs. So now you have this weird dichotomy, why we feel the need to get into the weeds here. Because Antonio Callaway, I think everyone would agree, and certainly NFL evaluators during the draft agreed that Callaway did have some checkered past, and that's why he fell in the draft, talent notwithstanding. But does he have what McMahon views as a, qualifying checkered past, so to speak? And then the issue goes, right, is the harm done, and maybe is it incurable to the extent that Antonio Callaway is hired, right? And then is it possible to be fixed? So Ben, I think that's really where this case is going to be won and lost, because we've all spoke about this case, kind of trying to figure out where the strengths and weaknesses lie. But Ben, if this is not a curable defense, right? If at the point of hiring, then the harm has been done. It's incurable. Is that the case? Is the case won and lost on that ground, or is not that easy?
I think it's a huge part of it. I think that you can paint a fairly black and white picture of whether or not Luck knew he shouldn't have hired Callaway and did anyway. There may even be evidence submitted to that cause. I think curability, materiality, and what the actual damage is done to the XFL and Vince McMahon were at the time are key there. Because yes, curable. Is it a financial thing? Is it that Oliver Luck signing him cost the league roughly $150,000 in a signing bonus and a week of pay and workers' comp? Or is it a reputational? Because somebody might plausibly say, okay, yeah, Luck screwed up there and he cost the league 150 grand for a player that never should have been on a contract. It didn't contribute anything to the league. So what do you say we take his $24 million, back out the 150 grand, and everybody's happy?
That's Luck's argument, right? I mean, he's argued that even if you factor out the delay issue and sitting on your rights and not acting for two or so months, alternatively, Oliver Luck is arguing that he could cure this simply by writing a check for $125,000. And as you say, back that out of the $24 million that would allegedly be owed to him under the contract. And you could get a window into the XFL and McMahon's theory of the case by reading the motions in limine. Every bad fact that goes against McMahon is the subject of a motion in limine, right? Exclude any and all evidence of the timing of the decision to fire Oliver Luck and exclude any evidence that this thing could have been curable. So all these motions in limine seem designed to prevent Oliver Luck from making the arguments that are going to help him prevail on his theory of the case. So let's kind of drill down on the curability issue. Callaway never played a game, never was heard from again. He participated in one practice, got injured. That was it. So is the harm to the league reputational from a player who never appeared in a single game? Or does it occur by virtue of the fact that they were on the hook for his injury guarantee of $150,000? Because if it's the latter, it's curable. If it's the former, then it's not curable. But how could it be reputational when this was completely, under the radar and never surfaced as a PR issue for the league, given the fact that he got hurt in his very first practice?
Well, I agree with you that he was never in a game, but TMZ Sports wrote a story about Antonio Callaway hiring and said that apparently the league has backed off of its demand for high quality character players. It was a one-day story. It was TMZ, but nevertheless, that was out there in circulation. So there was definitely a reputational hit, however ephemeral it may have been. Another argument that McMahon's going to make is that this was something that broke the relationship between Luck and McMahon, and that also can't be curable. There's a legal term of art somewhere in the document. I forget what it was, but like the trust of the employee and employer, that there was no coming back from that. He was so egregiously out of line in hiring Callaway in the first place. So I don't know how much legs that's got, but that's going to be his argument.
He was punished by being paid his full salary for 2 more months. Post hoc justification is going to be a big part of this case. And I don't see how the timing of the decision to fire him is anything other but the central issue in the case, notwithstanding McMahon's efforts to exclude it as evidence. I mean, that's what the entire case is about. Before you even get to the curability, one is this literally within the scope of the for-cause termination? And if so, was it waived by sitting on your rights? Does it reduce the bona fides of the claim? Because you can't just say something that had happened, ages ago can now surface as a reason to avoid contractual obligations when you allowed the employment relationship to continue unabated without any adverse job action. And we need to know what communications there were between Vince McMahon and Oliver Luck after the time that this injury occurred. If it was business as usual for 2 more months and he got paid every week and there was a good relationship and nothing was said between the two of them, how could that be a bona fide for-cause termination? I think that's going to be the central issue that the jury is going to have to consider before even reaching the threshold question of whether it's curable. In fact, I'm surprised the curability issue wasn't decided on the motion for summary judgment, because that seems to be more of a pure issue of law as to whether something like this can be carved out of the overall contract balance or whether it's reputational. I think the judge may have made a blunder here by removing that from the realm of an issue of law and putting it in the hands of the jury.
I just want to jump in here quick, just so people remember here. This is a case where Vince McMahon initially claimed that, Oliver Luck was fired for using his cell phone improperly. And then, for abdicating his role right at the beginning of the pandemic. As far as we're aware, there's nothing in writing really with respect to any of those, incidents, including the Antonio Callaway, right? That there was a curable opportunity for Oliver Luck. So in the words of Vince McMahon back in the day, right? Brett screwed Brett. He's going to say that Oliver Luck screwed Oliver Luck. The problem is there is nothing in writing to that effect. So again, I think it's going to be a strong argument on Luck's behalf. I'm not really sure what Vince McMahon says back to that. If it really was, this wasn't a pretext, we're just throwing things at the wall, this would have been in writing, specifically Antonio Callaway, right? That would have been in writing, either in January or February.
Yeah, and I think that's important to note because that was the reason that several of other McMahon's defenses were thrown out on summary judgment. It wasn't that Luck didn't necessarily do some of these things; it's that he was never given an opportunity to cure. Yes, it was the judge found that there's no denying that Luck used his company issued cell phone for personal stuff repeatedly, but he also found that nobody ever bothered to enforce that rule, and he was never told to stop doing it. So they bounced that. Also, with the allegedly disclosing confidential information to his brother-in-law at Wasserman, yeah, maybe he did that, but he was never told not to and to cure it. So there seems to be almost no record of any sort of adverse employment action, even a letter on file or an email from McMahon until April 9th. And I do think that is an uphill battle here.
Ben, there's also the issue of a company issued cell phone. And one of the claims that was made by Vince McMahon is that Oliver Luck used the phone for personal business. And that claim was thrown out. But nonetheless, during the discovery process, it turned out that Luck deleted, his cell phone, wiped it clean, or at least removed aspects of it that might have related to personal information. So how did the court address the cell phone issue? I know Luck was sanctioned. How relevant is Luck's handling of his personal cell phone? How relevant is that to the current issues of the case, given the fact that the judge dismissed the claim over misuse of the cell phone? Can you describe what happened with the phone and how the judge ruled?
Right. And this is one of the more curious parts of the case, because you could make a case that we buried the lead. A judge said that Oliver Luck destroyed evidence and lied about it, was fined $25,000 for it. Luck is a very well-regarded, high-reputation guy in sports business. So that alone could be a headline in an alternate world where there's not all this other stuff going on. Anyway, what happened was, and this is not in dispute, both sides admit this happened, that within an hour of Luck being terminated on April 9th, 2020, he deleted the browser history on his cell phone and also deleted a certain number of text messages. How many text messages is a point of contention. Luck cops to 20 or so text messages. The defense, McMahon's team, argues that it could have been 5 figures, more than 10,000 text messages, which obviously are two very different things. The judge sanctioned Luck for this. You're not supposed to do that, even though he hadn't been served with papers yet, or he hadn't initiated a lawsuit yet. Luck is an attorney by trade and had to know that this might end up in court, and he shouldn't have done that. However, it's only $25,000, which is not nothing, but for Oliver Luck, who's consistently earned a 6-figure salary for a long time, not a major problem. The reason it's only $25,000 is because the entire phone issue has been thrown out of the case and won't come up in trial at all. So it's a little strange that he was punished for destroying evidence that isn't actually going to be in the trial. McMahon's side wants to bring this to the jury, though. They say even if the phone matter isn't a part of the case anymore, we say this goes to Luck's trustworthiness.
Oh, and it could also bear on Luck's communications regarding Antonio Callaway. There could be a lot of text messages and emails that, contain admissions as to what he knew and what, if any, actions were taken by Oliver Luck. So I found that aspect of the decision a little surprising, but I would expect Vince McMahon's legal team to kind of raise the issue to undermine Oliver Luck's credibility in trial on trying to recover on the claim or prevail on the claim centered around Antonio Callaway, because they're going to take the position you spoiled the evidence. You deleted cell phone messages, and I think the court should draw or imply an inference, draw an inference that some of those text messages related to Antonio Callaway and contain admissions against interest. So maybe that issue could resurface in the context of the trial based upon the spoliation of the evidence, but the judge has already sanctioned him. When you destroy evidence in the context of litigation, the judge has at his or her discretion a panoply of punitive remedies. The judge can enter a default judgment or strike the pleadings, instruct the jury that you could draw an adverse inference from the destruction of the cell phone. The judge did none of those things in this instance and limited it to a $25,000 monetary fine, which should provide some sense of proportion as to how serious this transgression was, that it's really much ado about nothing. Otherwise, the judge would have left open the possibility of greater sanctions. And in the context of a trial, telling the jury that you're to draw an adverse inference from this destruction of the cell phone would be a very, very serious harm visited on Oliver Luck in the context of the trial. If the jury is instructed to believe that there was some dishonesty in those dealings. So I think that could be something to watch for in the context of the trial, notwithstanding the de minimis nature of the fine.
Dan, I think the point that we should address before we get too deep into it, again, this case stole the headlines initially that there was some personal guarantee between Vince McMahon and Oliver Luck. And, I think that's important here. Maybe people had just read the headlines and they've tuned off this case up until, we're on the eve of trial. So, Dan, you and I were kind of talking about it offline. There was a cause of action in this case, the breach of implied covenant of good faith and fair dealing. That was premised with respect to Luck against McMahon in a separate cause of action between Luck and Alpha. And this was, quote unquote, an absolute, according to Luck, an absolute, unconditional, continuing, and irrevocable pledge to pay Oliver Luck his full salary. And again, that was like $5 million a year. So some read the headlines and kind of said, okay, I guess this is a case of Luck versus McMahon. But to be clear, right, Dan, this is a case with Luck versus McMahon and Alpha, right? McMahon is still very much in the case, despite, the story that McMahon, at least partially, with respect to him, the breach of implied covenant of good faith and fair dealing has been dismissed with respect to McMahon, but not Alpha. But McMahon still very much remains in the case.
Yeah, those kinds of claims are they're always asserted. Breach of the implied covenant of a good faith and fair dealing is always asserted hand in hand with breach of a written contract. And courts throw those out all the time because when the allegations underlying the implied breach of the implied contract are identical to the allegations concerning the written contract, the courts will say, look, you're suing on the written contract. The implied contract theory is unnecessary because the same allegations are at play in the written contract breach claim. So that's why I think the implied covenant of good faith and fair dealing was dismissed as to McMahon and kept in maybe as to Alpha. But Alpha is also a pivotal party in this case because of some of the forum shopping that has occurred of late. Now, Ben, 2 years ago in 2020, Oliver Luck named Vince McMahon as the primary defendant, and McMahon tried to get the lawsuit dismissed because Luck failed to name Alpha as a necessary and indispensable party. So what is McMahon and what is Alpha trying to do now at this late stage? There's some gamesmanship going on with using parallel proceedings to try to get two bites of the apple. Can you provide some context here?
I know less about the fine legal points of this, but I can tell you what's happened recently is that this Luck McMahon suit we've been talking about is because McMahon personally guaranteed this contract. If this was Luck versus his employer, the corporation Alpha, it would be contained in bankruptcy proceedings. And Alpha doesn't have $24 million. Their creditors are expecting to get pennies on the dollars in the bankruptcy. But recently, the administrator of the estate of the bankrupt Alpha went after Luck in the context of the bankruptcy, tried to claw back money already paid to Luck, actually, using some of the same arguments that McMahon has used as why he fired him for cause. So, yeah, I don't know if that constitutes forum shopping, but they are attempting to raise similar issues in the context of the bankruptcy to undermine Luck's financial position.
Yeah, are they trying as part of this bankruptcy proceeding, which, by the way, was filed only a couple of months ago? Is Alpha also trying to litigate the issue over the remaining bonus and salary payments due Luck? Are there some parallel issues in both cases, or is it simply to claw back some of the prior payments? But I think it might even be an adversary proceeding where Alpha is trying to litigate the same issues that are in play in the current case between Luck and McMahon.
Yeah, I'm not sure I know, honestly, exactly how much these two things overlap, but there were some common threads in there that, some of the things that the bankruptcy administrator brought up was that Luck was particularly inept in negotiating venue contracts for the XFL teams. He got some bad deals that held down some of the teams in their stadiums for a long time. And then he just wasn't very good at his job. And he abandoned the job in the pandemic, which is one thing McMahon used as a claim for cause.
You're trying to relitigate that in bankruptcy?
Yeah.
So one of the measures of relief that Oliver Luck is seeking in the federal court case in Connecticut is he's seeking an injunction to prevent any further litigation of the bankruptcy proceeding because it constitutes, in Luck's view, blatant forum shopping. It's trying to get two bites at the apple. So it's very interesting that Alpha has been a party in this proceeding in Connecticut for such a long time. And a couple of months before trial, Alpha brings a separate litigation in bankruptcy court to try to litigate some of the same issues that are going on in the Connecticut federal court case. So I think that's also another issue. I mean, before we even get to trial, Ben, I think the judge is going to have a lot on his plate before a jury is even sworn in. So, just can you kind of describe what the next steps in this case are before a jury is impaneled and we actually go to trial?
You're right in identifying how complicated this is. And that's why it's such an interesting case, is that in a sense, it's about 6 days in January of 2020 and what happened or didn't happen in Callaway. But in actuality, there's these tendrils everywhere throughout the entire history of the XFL 2.0. The next thing is judges got to rule on these pretrial motions to say what can be or not be said in court. And that's maybe the whole show. If he comes down clearly on one side or the other, we're going to know where this case is headed, most likely.
Dan, did judges rule on these motions in limine before trial, or is it something that really is meant to educate the judge in advance of the trial, and then he sort of saves the ruling for when the issue actually comes up in the context of the trial? Like, when is the best time to rule on a motion to exclude evidence that hasn't even been sought to be introduced yet?
I mean, I would think you'd do it well in advance, right? Especially here, which we've kind of, danced around. So, Jane, it's a really good question. And we've touched on it a couple times here. But Oliver Luck, once he was found out he was terminated, there's the report or the allegation here that he wiped his phone clean. And in a case where, at least initially, part of the for-cause firing, or at least the allegation, was that Oliver Luck used his cell phone to, I guess, send out confidential information or use it for an improper purpose. So you have to imagine that the XFL is going to try to get in evidence of Oliver Luck's phone, though it might not actually be relevant to the remaining, cause of action and defenses in the case. So I think with respect to the phone, that's got to be decided very early on in the case, because the case can get very messy. They're going through what was or what should have been in his phone. And then again, there's still this issue of spoliation that's floating out there. Oliver Luck can be sanctioned up to $25,000, and that has to be made. A motion for those sanctions have to be made. I think it's within 14 days of the conclusion of the case when there's a verdict that's brought in. So, I would think, Dan, the decision on, these exclusionary motions has to be made early in the case. It can't be made as they come up. But that said, even when the case is over, we're not going to hear the end of this cell phone and how much really that played into the case.
I mean, I'd be surprised. Thinking about some of these pretrial rulings on motions in limine, I'd be surprised if the judge prevents Oliver Luck from raising the issue of the timing of when he got fired and the delay factor. That's basically his entire case. That really goes to the crux of why this alleged for-cause firing was a sort of a post hoc justification. The jury has to be able to take that into consideration. What do you think, Ben? Is that crucial to the case?
I agree with you that if the judge says he's not allowed to make any arguments about that interregnum between the Callaway and his firing, then it's going to be hard for him to make a case that it was pretextual. Closely associated with that, slightly different issue, is the question of materiality. I think we can also expect Luck to say, even if I did everything McMahon said, this was a 5-year contract for me to be the chief executive of this league. I was otherwise an employee in good standing of the league. This is simply not something that rises to the level of a fireable offense. I didn't sign 20 guys with character issues. It was one guy. It cost us $150,000. We spent more money to rent a stadium in Tampa for a week than that. So materiality and the lack of any corrective notice between January and April are a big part of Luck's arguments here. And I think this is another reason I like this case so much, is that what the contract law says and what a reasonable layman says about this case may be two different things. You and I see it as like, oh, we got a letter firing him for cause the day before they laid off all 400 other XFL employees, and 3 days before they went into bankruptcy. Clearly, this is just a pretext to avoid having to pay him his full contract. But that's not necessarily what contract law finds. And if this was a non-curable cause to fire, then he may not have had to say anything to him in that time period either. It just depends entirely on what the judge decides the jury can hear or not.
That's why the jury instructions are going to be so important. And each side has submitted their version of the proposed jury instructions, and how the judge integrates those two competing versions could go a long way to deciding who wins the case. And being able to get that right is going to be critical to, ensuring that the jury verdict remains immune from any type of appellate attack. This case is going to be tried in a federal court in the state of Connecticut, where Vince McMahon lives, where the WWE is headquartered. How much of a factor do you think the home venue would play in terms of potentially favoring the defendant? Is that something you think could sway the decision?
I mean, it can't hurt. I mean, McMahon is one of the most, maybe the most famous resident of Connecticut. I think we'd all like to think that the justice system is a little bit more sophisticated than that, but we saw it wasn't necessarily in the St. Louis NFL litigation. So yeah, I mean, I think he's had a pretty good track record in court in Connecticut. But on the other hand, there is a reputational issue that may mitigate his home cooking a little bit too. Oliver Luck, at least in our world in sports business, is a squeaky clean reputation type guy. He's very well liked. He's regularly mentioned as a candidate for high profile jobs. I believe at least there is some reason to believe he would be a candidate for the next commissionership of the Big 12. Nice guy. He's got the same reputation as his son, Andrew Luck, maybe not the flashiest personality in the world, but a solid citizen. And I guess, I don't know exactly how I describe Vince McMahon's reputation, but it's maybe a little bit the opposite of that. Yeah. So, I don't know what the overall upshot of that is. Yeah, it's on McMahon's home turf, but I think people who know Luck know that he's pretty well regarded businessman too.
True. McMahon hasn't had to be examined in a jury trial in almost 30 years. I think the last time he had to testify in any kind of a trial setting is when he faced indictment in the U.S. District Court in Brooklyn or Uniondale for steroid distribution. I think, the WWE and Vince McMahon tend to be very secretive. And I think one factor that could play into the settlement possibilities of this case is that if McMahon goes forward and, goes through with this trial, he's going to have to go under oath and talk about a lot of things that, may not reflect very well on his character or on his business savvy. So I think there could be a possibility of a settlement, because I don't think Vince McMahon wants to go through and appear in a trial and be a witness and be cross-examined by opposing counsel and have other things potentially come out. He may be asked lots of questions about his past, and there are things in his past that are very negative.
We should probably mention it before we get out. I mean, there is at least public reports of certain text message exchanged between McMahon and Oliver Luck. One, I keep circling this Johnny Manziel thing. There's a text that's reportedly sent between McMahon and Oliver Luck. McMahon says to Luck, "How long are you going to play this game, Oliver? There is no chance in hell for Manziel to play for us. I will not change my mind. So what's your plan?" Right? So part of this could be a really entertaining cross-exam of Vince McMahon. These, back and forth about players like Manziel. So we'll see. Dan, I think it could be very entertaining, knowing like the closet wrestling fan in me. Vince McMahon has a flair for the dramatic. I remember during those steroid hearings, Dan, he had a big neck collar on because I think he was trying to build up some sympathy. But from a number of levels, this could be a very, very entertaining proceeding. But Dan, we've got this far, and I think, Ben, credit to you for picking up on the story when really I haven't seen any coverage of this on a national level. Yeah. This is a case that is I don't see this case settling, and maybe it will, and maybe everything's all for naught. But settlement conferences have proved unsuccessful. It's $20 million, and McMahon, for better or for worse, doesn't seem willing to listen to Luck's side of it. And again, I think we should point this out. Luck has not found further employment since this litigation happened. So Luck is putting all of his energy in this, and McMahon obviously has been running a $1 billion company in the WWE. So the two parties are in very different positions than they were when, Oliver Luck was making $5 million a year.
The last question I have is the timing. So Ben, we got a pretrial conference coming up. Before we let you go, When's the trial going to take place? How long is it going to be for? How many days? And of course, will you be there? I mean, you live in New York City, Connecticut shouldn't be too tough.
So jury selection is currently scheduled for July 11th. I believe that's the day before the Major League All-Star game, if that helps you orient yourself in the calendar. And they seem to think the trial is going to take between 5 to 7 days. So, that's sort of a nice specific time frame. And I guess I don't know for sure if I'll go up and cover it, but if it actually gets to that point, I think there's a strong case to be made. Just the color alone of that courtroom should be pretty spectacular, frankly, in a way that rarely happens in this. That's another point I wanted to make, is that one of the reasons you probably haven't seen so much coverage on this is everyone just sort of assumed it would eventually be settled. This is a math problem, right? You say you owe me 24, I say I owe you 0. It's probably in everyone's interest to find a number that we're all happy with and just go away. But that's not how Vince McMahon does business. So we're going to go to the Royal Rumble, if I can be slightly trite.
I like it. We like wrestling analogies here. We try to weave them in. I think we're good. I think it's a really interesting and fascinating trial. We'll continue to pay attention to it. The clock is ticking for some type of settlement here, but we shall see. Ben, thank you very much for joining us. So that was Ben Fischer of the Sports Business Journal. Again, you can find him on Twitter at Ben Fischer, FISCHERSBJ. So, Dan, I think where we left it, right? July 11th is this trial date. This wouldn't be a proper sports law podcast if we didn't give out some predictions. So, Dan, I'll give you the honors. What do you like here?
Well, if I was Vince McMahon, I'd be trying to settle this case as quickly as possible. Of course, he's worth $2.5 billion. He's playing with house money, $25 million. It's bupkis to him. For Oliver Luck, who hasn't secured a similar position in the aftermath of his departure from the XFL, I guess the amount of money is much more meaningful. But I have to say that Luck has a very strong case from my lens, because the most important factor for me isn't the technicality of whether signing Callaway violated the contract or whether it's even curable. The delay factor, the sitting on one's rights, the XFL and McMahon taking no adverse action against Luck until the league was ready to fold, sounds like the classic post hoc justification, pretextual reasons given for firing. And it seems so evident to me. And when you consider all the other arguments that McMahon raised, they carry with them this hint of, being pretextual. He misused his cell phone. He didn't devote all of his full time to the league once the pandemic started. It just seemed to be throwing stuff against the wall, and the one that's stuck on summary judgment, or at least the one that remains alive, is this issue with Antonio Callaway. I think it's a bogus defense. It seems so clearly pretextual to me that I have a hard time believing that jurors are going to buy into Vince McMahon's argument. So I think Luck wins, and it wins going away. If it goes to a verdict, it will be a fairly fast verdict. The jury will not be deliberating for days. They'll come back and return a verdict in Luck's favor within 2 hours.
Okay, so
for the full 24 million.
That is a boldest of bold predictions. Let's not forget, WWE is headquartered in Stamford, Connecticut. So if someone wanted to say that McMahon has home field advantage, you're not necessarily wrong. I think part of the prediction, for you and I both, this is reputational. For Oliver Luck, he remains unemployed since he was fired. So I think he's trying to clear his reputation as much as he's trying to get paid. Vince McMahon, let's not forget, he had a failed XFL venture in the early 2000s, and this was a second failed venture. So if Vince McMahon can put the blame on Oliver Luck through the course of this trial, maybe he's going to try to do this. My first prediction is I do think this is going to trial. Again, 99% of cases settle before trial. So maybe it's a little bit of a bold prediction for you and I both that this will actually go to trial and see the finish line. And I think substantively, people forget, right? Vince McMahon had 4 defenses to this case, and the judge wiped them all out with the exception of this Antonio Callaway case. And I think you and I think that McMahon's decision to fire Luck would have been a lot stronger, that it was specifically based on Callaway, if there was something in writing. Now, the docket has been sealed. As far as you and I know, there was nothing in writing that keys, right, this April 2020 firing to this January decision to hire and not fire Antonio Callaway. So I think this lack of writing is going to be very key. And I think, absent some type of text or email that we don't know about because the record is sealed, it's going to be very hard for McMahon to show that this reason, and this reason alone, Antonio Callaway was the reason that Luck was fired here.
Wait,
so
when you talk about the writing, are you talking about the writing in connection with the timing of bringing this to Luck's attention? Because he could have put it in writing in April, 3 months later, and that wouldn't be any more meaningful than firing him orally? Did he put it in writing at around the time of this alleged, incident, which happened?
I don't know if he ever put it in writing before this lawsuit. I mean, it could be.
Would that have mattered if it occurred months later?
It would. Well, no, not if it occurred months later, but per the terms of Luck's employment contract, written notice had to be provided for a curable opportunity. So I think that's part of the case. But on an overall level, you have to put someone on notice if you're really firing someone for a particular reason. Best business practices, put it in writing, put a memo to the file. And as far as you and I are aware, Dan, there is nothing to memorialize that. So I think that's a fatal flaw in the case. And we'll see. Again, we have to preface this entire podcast that a lot of the record has been sealed. But as far as we know, there is nothing like that to memorialize that McMahon at the time, prior to this lawsuit, felt that the Antonio Callaway decision was a fireable offense. We're not aware of it. And without that, I think the case kind of falls apart. The defense falls apart. Let's be clear.
I would say McMahon is definitely the clear underdog in this lawsuit. Putting aside the fact that this case is being tried in his home state, given the facts that we do know from the docket, which is transparent to us, I can't see him as anything other but as big of an underdog as ever occurred in the WWE since Ivan Koloff wrested the WWF title from Bruno Sammartino in the early 1970s. I think McMahon's an even bigger underdog than that.
Mankind was a pretty big underdog when he won the WWE title from The Rock, and Daniel Bryan was kind of a big, now known as Bryan Danielson, but two big underdogs. I think McMahon is right up there. Certainly, the whole docket we don't know about, but I think that is fair to call him the underdog. And that said, Dan, this podcast is sponsored by Underdog Fantasy. Head over there for DFS, for best ball leagues. You can use our promo code CONDUCT for a $100 match bonus. That is the place where you should be going to play all of your fantasy needs. Okay, Dan, I think we did a good job breaking down this case. Again, sometimes we have stories that are really at the forefront, like we covered Watson very closely, but this is a case that I don't think is getting enough attention. And those are some of at least my favorite episodes when we tell our listeners, hey, you should be paying attention to this particular case. Yeah, Dan, anything to add before we put this episode in the books?
No, I just hope it goes to trial and we get to see Vince McMahon in court under oath being questioned about his entire business history. So I'm just hoping and praying this actually comes to fruition. But no, besides that, we're going to monitor this. And, if there's going to be a trial, we're a few weeks away from it. So this could be the big sports law trial, at least for the month of July, if not the entire summer.
We will keep tabs on it, and it's a case that people should be paying attention to. Okay, we will put this episode in the books. For Dan, myself, the Conduct Detrimental family, we will see you next time on another episode of Conduct Detrimental.